Senator Runner.
Thank you, Madam President. I rise as a joint author of the bill. It simply gives the FTB flexibility to consider a divorce agreement when determining if one spouse can be relieved of a tax liability. This issue comes up more frequently than you'd think. Approximately 15 of these cases have come before the board in the last 4 years. And these cases represent real taxpayers with real challenges. If two people reached a mutual agreement regarding their divorce, then a tax agency should have the authority to follow the terms of the agreement. Most of the cases that come before the board involve women who believe they were protected by their divorce agreement, but who find that their only recourse is going back to court or paying the tax liability themselves, telling taxpayers they must go back to court in order to enforce a divorce agreement is inefficient government. Tax agencies should respect the divorce agreements, and I ask for your aye vote.
Thank you very much. Senator Stone.
Thank you, Madam President. In divorce proceedings, support can be characterized in two ways. It could be paid by one spouse to the other with after-tax dollars not taxable to the beneficiary, or paid by one spouse to the other with pre-tax dollars wherein the payment is tax deductible to the payer and tax reportable to the beneficiary. There have been many inconsistencies with the beneficiaries not reporting the income when required to do so by their divorce decree, or when a payer is required to make payments after taxes but still reports the payments as a tax deduction. The divorce decree appropriately spells out these details, and the Franchise Tax Board should depend on them for their tax determinations. I want to compliment my colleagues for bringing this forward. It's certainly going to give the FTB a lot of clarity on these issues. I urge and I vote.
Senator Fuller, would you please close?
Thank you. I ask for your aye vote. It's bipartisan support. Thank you.
Thank you. Is there any objection to the use of unanimous roll call? Seeing none, ayes 35, noes 0. The measure passes. File item 108, Senate Bill 572. Mr. Secretary, please read.
Senate Bill 572 by Senator Pan, an act relating to school facilities.
Dr. Pan.
Thank you, Madam President. Members, I rise to present SB 572, a measure that will establish a district advisory committee prior to closing of a school composed of 7 to 11 members that may include parents, teachers, students, school employees, and community stakeholders to advise the school district on whether or not to close a school and the best course of action after the decision is made. Closing a school can profoundly affect families, entire communities, district personnel, and of course students. However, a decision not to close a school faced with declining enrollment, performance, and financial support can be irresponsible. School closures affect academic performance both for transferring students and students in receiving schools. On one hand, school closures may free up resources for better performing schools where students from closed low-performing schools may be reassigned to boost performance. However, a drastic change in schools may also increase the dropout rate, reduce academic performance, or may affect a child's healthy development. School closures may also affect the community, including businesses and community-based organizations, which share a symbiotic relationship with the schools and families who all want the best for their children. Although the immediate effects of closing a school may be painful, the long-term effects can be beneficial. Either way, those most affected must have an active voice during the difficult and life-altering process. Currently, the Department of Education encourages, but not requires, the use of district advisory committees when school districts face a school closure. Unfortunately, that means several communities, particularly low socioeconomic, underrepresented communities, do not have a voice. Although many school districts use district advisory committees for school closures, many do not. For example, in 2013, the Sacramento City Unified School District faced the decision to close 11 schools but did not establish an advisory committee. The district ultimately chose to close 7 schools, but the decision was made without consultation with those most affected, which left hundreds of families and community members confused, frustrated, and voiceless. SB 572 would not overburden schools with high recurring costs because school closures are very rare, but serious occurrences in California. Many school districts already use district advisory committees. However, for the districts who do not do this, an important investment because of the severe economic, academic, and social consequences of closing a school, particularly for low socioeconomic communities. SB 572 outlines the membership and responsibilities of the District Advisory Committee, but most importantly, SB 572 will help the community work together to determine their best course of action to help their children during this difficult period of the school closure. I respectfully ask for an aye vote.
Thank you. Senator Stone.
Thank you, Madam President. I rise in opposition to SB 572. I think this is a local control issue. I think as a former local elected official, one of the things that we don't like is when the state tells us what to do, when the federal government tells us what to do, when we see our constituents on a weekly, biweekly basis and hear their concerns. Why would we want to preempt any decision that a local school board would have? They have meetings, they're subject to the Brown Act. There has to be a compelling reason why they'd be closing a school down, probably declining enrollment, consolidating with other schools to better spend their money. I think this is meddling. I don't think we should be meddling in local government's responsibilities and place yet another mandate on them. Let's let the school boards know, I think, is the best for their constituents, their students. Let's let them make the decisions on behalf of the taxpayers in that area and promoting good education, and let's not meddle into their affairs. I urge a no vote on SB 572.
Senator Morlock, put your mic down. Okay, thank you. Senator Allen.
I just have to associate myself with the comments just made by the previous senator.
Thank you. Any further discussion or debate? Dr. Pan, please close.
Thank you. When certainly as a member of the community and pediatrician, I've worked closely with many schools, and I know that while certainly a school is something that's overseen by school district, the school also, of course, has a very important role in most communities as a center for the community where people interact. Families are bringing their children, so forth. There's actually becomes a center, a hub of activity as well, and I think it's important that when school districts decide to close a school, and I know that school districts have to do that at times, as I mentioned, that they should be getting input from people in the community as well as, of course, people who are attending the school. This basically calls on school districts to establish these committees. Many school districts do this already, and that the districts provide advice to the school boards. I believe that actually will lead to better outcomes than situations where school districts close them without getting community input. This is really about ensuring that our communities have an input, that the people who actually work and go to school and their families have input before a district makes such decisions. I respectfully ask for an aye vote.
Thank you. Mr. Secretary, please call the roll.
Allen? No. Anderson? No. Bates? No. Bell? Aye. Berryhill? No. Block? No. Canella? No. De Leon? Fuller? No. Gaines? No. Galgiani? Glazer? No. Hall? Aye. Hancock? Hernandez? Hertzberg? Hill? Aye. Whistle? Aye. Huff? No. Jackson? Latta? Leno? Leyva? Liu? McGuire? Mendoza? Aye. Mitchell? Aye. Monning? Aye. Morlock? No. Morrell? No. Wynn? No. Nielsen? Pan? Aye. Pavley? Roth? Runner? No. Stone? No. Vidak? No. Wachowski? Wolk?
Call the absent members, please.
De Leon? Aye. Galgiani? No. Hancock? Hernandez? Aye. Hertzberg? Jackson? Latta? Leno? Leyva? Aye. Liu? McGuire? Nielsen? Pavley? Roth? No. Wachowski? Wolk?
Senator Pan moves the call. Let's return to file item 90. Senator Hueso, file item 90. SB 328. Mr. Secretary, please read.
Senate Bill 328 by Senator Hueso, an act relating to rental property.
Senator Hueso.
Thank you, Madam President and Senators. In 2013, the American Association of Poison Control Centers reported more than 84,000 incidents of pesticide exposure in people in their homes. 42% of these involved children who are more susceptible to exposure and developing illness as a result. The California Structural Pest Control Act requires that licensed pest control professionals provide tenants with written notification before a pesticide application. The notice must include basic information about the targeted pest, the pesticide used, frequency of its use, and basic health and safety resources, including local emergency contact information. If a landlord, however, chooses to self-apply an over-the-counter product such as an aerosol, a spray, or a fogger, he or she is not required to notify tenants of pesticide use. As a result, tenants who are not informed of pesticide use in their home are put at risk of unhealthy exposure to harmful pesticides and are not afforded the right to take precautionary measures to avoid unwanted pesticide exposure. SB 328 would ensure that a tenant's right to know and the ability to take precautionary measures against pesticide exposures are afforded to them. This bill would require the landlords and property managers to provide tenants with notifications almost identical to those currently provided by professionally licensed operators in order to ensure tenants are fully aware of the pesticide products used in their homes and allow tenants to take any needed precaution to avoid pesticide exposure. As promised in committee, we have worked very hard with the opposition to get their support in the bill, to work out little details in the bill that needed to be improved in order to make this bill more practicable. I wanted to mention some of those changes that were made to the bill. We clarified what affected tenant meant by covering, there's a item B1 is separated into B and C. B covers pesticide applications to individual units. C covers pesticide applications to common areas. Each section has distinct notification requirements. The definition of pesticide was also made more clear. We added language to clarify the bill does not cover antimicrobials that are also technically classified as pesticides. And these are the agents that usually are used to fight bacteria and fungus. And we wanted to exclude that in this process because it doesn't have the same effect on humans. An additional change was identified as problematic by the Department of Pesticide Regulation. We are looking into alternatives that may work instead in this area. So I think we're making progress there. Also, in addressing the neighboring units in the bill provided clarity on neighboring units to mean adjacent unit next to and directly above and below, consistent with pest control best practices. Notification methods, we added electronic delivery. We made personal delivery consistent with Section 1954 regarding notice to enter units. And in timing of notification, for use in common areas, we removed the 24 hours advance notice and simply require the notice to be posted before the use of pesticide and remain posted for 24 hours. Tenants' ability to waive 24-hour waiting period, we allowed for the tenants to waive the waiting period upon receipt of written notification and allowed the tenant to waive via electronic delivery. We also added language regarding landlord liability, saying that providing a notice is sufficient. And in cases of routine scheduled use, we provided a clause that provided a notification procedure that requires a single notice for routine application of pesticides rather than having to post a notice every time the pesticide is used. that is consistent with the requirements of licensed pest control operators, and that's pretty much it. I wanted to state that on the record for the benefit of the members to know what they're voting on, and I would ask for their support for this consumer protection measure.
Thank you very much, Senator. Is there any discussion or debate? Senator Stone.
Thank you, Madam President. This is a classic case of the state creating a problem to create a solution. Here we're going to have an onerous regulation on landlords, of which I'm one, which is going to create frivolous litigation leading to higher rents for our renting citizens that pay some of the highest rents in the nation. This applies to over-the-counter pesticides that are over-the-counter for a reason, because they don't create a danger for the applicators or the people living in homes where the applications are being made if they follow the directions on the bottles. Are we really going to start regulating Raid and ant sprays? Have we really seen a case where a tenant is being poisoned by a can of Raid used by a landlord? I would ask the author to give me one example. Are we regulating medicated mouse traps? Are we regulating spraying for spiders? My friends, does this problem really rise to the level in the state that has so many other problems demanding our attention that we need to waste time on this type of legislation? Are we really solving an existing problem or creating a quasi-problem with which to solve at, of course, taxpayer expense? I must note that he talks about fogging. Well, landlords don't have the legal right to go into an apartment or go into a home that we're leasing and set off a fog bomb in there because you may have some type of a infestation within these units. It's usually at the request of the property owner that will follow the directions on the bomb and will leave their residence so that these infestations can be under control. If you really look at the literature on these over-the-counter insecticides, you will find that most of the poisonings are not caused by landlords, but rather by citizens buying over-the-counter insecticides and simply not following the instructions. Maybe we should be supportive of making sure those instructions are bolder and clearer to make sure that consumers use them in a more safe and efficacious way. It's the tenants that use these products indoors and that don't read the instructions on the products that causes the majority of the problems, not the landlords, that the spray may be used on the exterior of the home with an external product that through the ambient air will not cause any problems for the beneficiaries living in the home. And now we have to take the extra step when we're using Raid to get rid of ants on our properties. We have to send a notice now to the neighbors that we're going to be using Raid to get rid of the ants. The disclosure requirements even exceed, my friends, listen to this, even exceed the professional requirements that we require of professional pest control operators. This is ridiculous. Please stand with me and say no to this horrible type of legislation. Please, I urge you, vote no on this.
Any other further discussion or debate? Seeing none, Senator Huesel, please close.
Tenants have the right to know what chemicals are being put in their homes. It's that simple. We don't know that these chemicals are over-the-counter chemicals. But in the event that they are, they will know that. I think there's a basic right for a tenant to know what applications are being their family members are being exposed to. Nobody knows the health constraints or the challenges suffered by children better than their parents. If there's a product that children are allergic to or have adverse reactions to, the parents should know that if that product is being introduced to a home. I think a simple notice is not too much to ask to help protect people's health. So I don't think this is a cumbersome requirement. If you want to reduce it to a matter of Raid, if the issues are that tenants themselves are exposing themselves to products because they're not reading them, that's a different matter than if you put your trust into somebody providing you with facilities, and that person in turn violates that trust by applying a product that has a detrimental effect on your family's health. And I think that's an area that our state needs to be involved in, because people are exposed out there in the community by people that, by landlords who are not well versed in the application of pesticides, that are taking matters into their own hands without an education in the area, and putting people's lives at risk. So if they're experts and they know what they're doing, it wouldn't be very hard for them to explain that to the tenants in a very simple notice. I don't think it's an onerous requirement, and I hope we all support it.
Thank you. Mr. Secretary, please call the roll.
Allen. Aye. Anderson. No. Bates. No. Bell. Aye. Berryhill. No. Block. Aye. Canella. No. De Leon. Fuller. No. Gaines. No. Galgiani. No. Glazer. No. Hall. Aye. Hancock. Aye. Hernandez. Aye. Hertzberg. Aye. Hill. Hueso. Aye. Huff. No. Jackson. Aye. Lara. Leno. Leyva. Aye. Liu. Aye. McGuire. Aye. Mendoza. Mitchell. Aye. Monning. Aye. Morlock. No. Morrell. No. Wynn. Nilsson. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. No. Stone. No. Vidak. No. Wachowski. Aye. Wolk. Wolk, aye.
Call the absent members, please.
De Leon. Aye. Hill. Aye. Lara. Leno. Mendoza. Wynn. Nilsson.
Ayes 21, noes 14. The measure passes. File item 111, amendments pending. File item 113, Senate Bill 722. Senator Bates. Mr. Secretary, please read.
Senate Bill 722 by Senator Bates, an act relating to sex offenders.
Senator Bates.
Thank you, Madam President. Members, Senate Bill 722 would authorize a felony penalty of up to 3 years for child molesters and rapists who willfully remove or disable a global positioning system known as a GPS tracking device. Amendments were taken in the Senate Public Safety Committee to tighten SB 722 to ensure this new felony would apply only to dangerous persons under supervision who intentionally evade supervision with the purpose of causing further harm, as distinguished from hapless supervised persons who, without this intent, nevertheless allow or cause their GPS to fail. A recent killing spree in Orange County left 4 innocent women dead, and the murders were later linked to 2 high-risk convicted sex offenders who at the time were on GPS supervision. After more of the investigation developed, we found out that not just once, but twice, these men cut off their GPS tracking devices and left California. Existing law does not provide the tools to keep offenders locked up. 4 women were murdered, and yet had these men been apprehended and held behind bars for defying law enforcement the first time, perhaps later murders could have been prevented. The bill focuses on high-risk predatory sex offenders by limiting its application to the offenses deemed most egregious by the legislature when it approved the one-strike rape law. Among these offenses are rape, lewd, or lascivious acts against children, sodomy, oral copulation, and continuous sexual abuse of a child. It is not comforting to the families of these innocent Orange County victims when twice these offenders were apprehended, twice they cut off their devices, and then committed 4 murders before being arrested. We must show the victims' families that this legislature is serious about these crimes. SB 722 has bipartisan support, has received no votes to date. The bill is needed today more than ever to ensure that justice is served. It has received support from the Orange County Sheriff's Department, Orange County District Attorney, the California District Attorneys Association, Crime Victims United of California, Peace Officers Research Association of California, the San Diego District Attorney, the Orange County Board of Supervisors, and the California State Sheriff's Association. I respectfully ask for your aye vote.
Senator Nguyen.
Thank you, Madam President. I rise in support of SB 722, sponsored by my fellow colleague from Orange County. Last year, in our own backyard, as mentioned in Orange County, 2 sex offenders intentionally moved their GPS tracking device and raped, murdered these 4 women. By willfully removing a court-ordered tracking device, these offenders violated their term of release. Those under court order supervision must face high penalties for making a deliberate attempt to evade law enforcement. SB 722 would send a very strong message to any convicted sex offenders that tampering with their monitors will result in serious consequences. I urge an aye vote on this measure to protect the innocents and keep these criminals away from our family, women, and children. Thank you.
Thank you. Would you like to close, Senator?
Yes, I do. I'd like to thank the staff of the Public Safety Committee, the chair of that committee, and that committee for a very deliberative discussion on narrowing the bill, and do ask for your support.
Thank you. Is there any objection to the use of unanimous roll call? Seeing none, ayes 37, no 0. The measure passes. Colleagues, we're going to break for our caucuses. Let me just update you all. We had 63 measures eligible for action to be taken upon today. We have successfully done that on 14, leaving 49 items left for consideration today. We will recess until 1 o'clock. Colleagues, we're going to return to file item 123 out of deference to our colleagues who are serving on conference committee. Again, we'll begin with file item file item 125, Senate Bill 140. Senator Leno. Secretary, please read.
Senate Bill 140 by Senator Leno, an act relating to electronic cigarettes.
Senator Leno.